This Honorable Court of Appeals of Tennessee is in session. Please be seated.
Good afternoon and welcome to the 1:30 docket of the Tennessee Court of Appeals. I'm Judge Neil McBrayer. To my right, your left is Judge Kenny Armstrong. To my left, your right is Judge Roy Morgan. We have two cases on the docket today. I see some frequent flyers, as it were, in appellate court here, so they don't need to hear that, but for those people that are just glutton for punishments and watching this online, each side will have 15 minutes. The appellant will be able to reserve up to 5 minutes of rebuttal time. Ms. Dempsey, is there any preliminary matters we need to attend to?
No, Your Honor.
If you'll call the first case, please.
David Burns versus Ford Construction Company.
Afternoon, Your Honor.
Good afternoon.
Chuck Holliday for the appellant, Mr. Burns. I would request 3 minutes for rebuttal, please.
3 minutes for rebuttal. Yes, sir.
May it please the court. This court should reverse the trial court's order granting summary judgment because the trial court failed to draw all reasonable inferences from the evidence in the light most favorable to the plaintiff. It's helpful in this case to first start talking about everything that's not in dispute. Mr. Burns worked for Ford Construction. He had a work injury. He submitted that, made a claim for workers' compensation. An MRI showed that he had a herniated disc at L2, L3. After a conservative course of treatment, he was released full duty with no restrictions by the authorized treating physician. He presented to Ford ready to work, but Ford discharged him 2 days later, according to the separation notice, due to a permanent lack of work. Less than 30 days later, however, Ford advertised on its Facebook page that it was hiring for multiple positions, including carpenter. Mr. Burns went to apply for work there and was told the positions had been filled.
Let me ask you, counsel, based on the nature of Mr. Burns' injury, don't you concede that he could no longer do that work as a carpenter for Ford Construction Company?
No, Your Honor. Mr. Burns showed up. He was released by the authorized treating doctor under workers' compensation. No restrictions, full duty. According to Dr. Brophy, he could go back to work and do that job as he had done it before. And Mr. Burns presented to Ford with that release, prepared to do what they were asking him to do.
And it's your contention that he could do that kind of work even now?
It is not my contention he could do that type of work now. I think the proof in this case, in the record, is that Mr. Burns testified that he probably could not do that work anymore, and so that would cut off his damages, so to speak, later in time. But at the time that we're looking at, and it's very important that this court remember, in a workers' compensation retaliation case, we're looking at the moment in time before the retaliation. What was the employer thinking at that time? And in this case, the evidence shows that at that time, he presented to Ford, having been fully released to do that job again, and went to them. And they didn't talk to him. They didn't give an opportunity to discuss problems. They didn't sit and talk to him. They said, go home, and 2 days later, he was discharged.
Okay.
After the Facebook posting is basically where the parties diverge on what the evidence shows. Ford testified after the lawsuit was filed, their position was that they had concerns about his ability to do that work. And they also testified there was no lack of work at Ford. They just had a lack of work for Mr. Burns. That evidence establishes the prima facie case right there. Employee, work comp claim, discharged. The final prong was a substantial basis, the firing. And the courts have said that you can show that the reason given for the termination was false. In this case, we showed that. Prima facie case established.
Well, counsel, how is it shown to be false, though, in this case?
He was laid off for a permanent lack of work, and Ford said there is no lack of work.
But is that what the notice actually said, a
Yes,
permanent
Your
lack
Honor.
of work?
Yes, Your Honor. They checked lack of work, permanent.
Now, on that form where you check off the reason for the discharge, how many different options do you have?
I believe there is discharge, lack of work. There may be a third one other, and then there's a box where the employer can explain the reason for discharge. And as best I can recall, Your Honors, that was left empty.
All right. Let me ask you, if they'd filled out in that block lack of work because of his inability to do his job as a carpenter, would we be here today, counsel?
I think it would have made Mr. Burns' case much harder. I can't say whether we would be here. The evidence that we have received throughout the litigation suggests there was that animus toward the work comp claim, but would it have been enough to initiate the claim at that point? Perhaps, because he had testimony from Mr. Burns that before his work comp claim, he had two other injuries that are noted in the record where they were minor injuries. He had heat exhaustion and I think something in his finger. He went back to work, didn't make a claim, no problem. In this case, after he made his work comp claim, he testified that he began having these negative problems with Ford employees, particularly Mr. Baggett. The record discusses what Mr. Baggett said to him, which I won't repeat here. It's not necessary. It's in the record about his claim, and that other employees had problems with him. So would there be enough to make out a claim? It might not be on that argument, Your Honor. It might not be that showing that the separation notice was different than the reason. If they put in there, we were firing him because of his health. But, and it's difficult to go back and go through that whole analysis because as I'm sitting here thinking during this argument, there is evidence in the record, again, that was not the reason. Ford has said we had concerns, but there was nothing in the file. In the Torres court, the court said the employer said the employee had committed theft and tardiness, and there was another basis, fighting. None of that was noted in the employee's personnel file. And the court said that's evidence that the employer's statement is not correct.
Yeah, given the nature of the work that Ford does, you would expect there would be a lot of injuries from that heavy industrial work. During the discovery stage of this case, did you find any evidence that where employees were injured, that Ford then, if they made a workers' comp claim, that they were terminated?
Your Honor, we did request a list of all employees and reasons they left, and at that we did not pursue that, but there were questions about whether or not why a certain employee was terminated. But I can't say as we sit here today and cite to evidence in the record of other instances where Ford had hired or fired people because of that.
Okay.
And honestly, Your Honor, I don't think it's necessary in the context of this case. I don't know of any case law that says we have to show that the employer, that would go to the punitive damages aspect. That's one of the Hodges factors for the amount of punitive damages, is whether the defendant has been subject to previous punitive damages awards. But in terms of showing other employees were fired because of their injury, you've got a huge issue there in terms of running down all of these employees, taking depositions, finding out why they say they were fired, why does Ford say they were fired. In this case, we have enough because the emails in this case show that Ford had a negative attitude toward Mr. Burns' claim. They didn't like it. They thought he was faking. He's got a herniation at L2, L3, and they're sending emails saying, we want surveillance. When is this claim going to be over? We want to close this claim up. And their actions don't correspond to their words. When they say they were concerned about his safety, no discussion with him. There are Ford supervisors who say they saw him lifting heavy objects. If they were concerned about his safety, one would expect they would have gone to him and said, Mr. Burns, your doctor has put you under these restrictions. We want you to operate within these for your health. They didn't do that. They said, just keep watching this guy. And so the evidence shows that, and that's one of the arguments that Ford makes in this case, is that there's evidence there from which you could see how we could be concerned. That's different than pointing to evidence in the file showing that their reason is supported by the evidence. There is no evidence in the file in the record where Ford said, we're concerned, Mr. Burns, about your ability to do this job. We have concerns about your safety. And so that shows, as Ford notes, let me see, at page 13 of Ford's brief, the safety director repeatedly saw Mr. Burns lift things outside of his restrictions. Instead of counseling him about that, they said, keep watching him. Ford made the decision, according to Ms. Keeling, that it just wasn't, quote, it just wasn't good to keep him employed. At the end of the day, this court is faced with the question not of whether Ford has enough evidence to support its position. It may, and a jury could side with Ford. But the question before the court is taking those emails and drawing the inferences in the plaintiff's favor, which the court is required to do. Have we created an issue of fact? And I submit to the court that the evidence in this case shows that we have done that. The emails are the biggest part, and the court discussed those, and the court drew the inferences against that and said, well, I don't think they support that. But the court's job is to look at that and say, if I take the strongest view for the plaintiff of what these shows and what this evidence shows, is it enough for a jury question on that? And that's where we submit that the court erred in this case. The emails after Mr. Ford was terminated, they said they wanted to make sure that everybody in Ford knew that there was litigation pending, quote, just in case David Burns tries to come around and be rehired. This is textbook evidence that Ford was punishing Mr. Burns for filing this workers' compensation claim. They didn't believe him and they didn't like it. Now, after the fact, they've appeared to develop this feeling of we had concerns about whether he could do the job. But as Ford notes, Ford cites this case in its brief for the Davis versus Nissan case. In that case, the client was released full duty with no restrictions. Nissan went and had a doctor look at that person and do an evaluation. And I think there may have even been a second doctor. And then they sat down with the employee and they said, we don't think it's good for us to continue employing you here because of your injuries. That's what this doctor said and this doctor said. Well, that didn't happen in this case. And Ford talks about Dr. Chung a lot in their brief. And the simple fact is Dr. Chung wasn't in existence at the time that's relevant to this court's inquiry. At the time Ford terminated him, Mr. Burns had never been to Dr. Chung. So anything Dr. Chung said after the fact may help them support what they're saying, but it's not relevant to a decision of what was Ford thinking. Unlike a lot of these other cases I was saying earlier, the Torres case about theft or fighting, this case goes to the state of mind that Ford has. And the Supreme Court said in the TWB case that in a state of mind case, summary judgment is rarely appropriate because you have to look, the jury has to look at the person testifying and determine their credibility. The bailiff and I were talking before this argument about one of the things during COVID was over the screen and how hard it is to see people's body language. The jury should hear Ms. Keeling testify and decide whether or not Ford, what their true motivation was. And for that reason, this court should reverse the trial court and remand it for trial on the merits. Thank you.
Good afternoon, Your Honors. James Cresswell for the Applee Ford Construction Company. The court was correct in granting summary judgment in this case based upon the record before Your Honors. And I think the key to this decision is to look at the burdens that the court had to deal with. Admittedly, he has to draw all reasonable inferences in favor of Mr. Burns. However, as this court's well aware, Rye is now the law of the land. And with Rye, the record is what it is at the summary judgment stage. And also with Rye, we have affirmation that the McDonnell-Douglas burden shifting test is now back, and it is the law of the land in these types of cases. So what does plaintiff have to prove using the test before this court and the McDonnell-Douglas burden shifting? You first start off with the prima facie case. We agree on 3 of the 4 factors. Like most litigants, we disagree on the 4th, which is, was this was a wrongful termination the substantial reason they actually terminated Mr. Burns' employment? Now, there are things you can look at for that, and he can do it with direct or circumstantial evidence. Admittedly, he has to use circumstantial evidence. Looking at his briefs and at the MSJ, at the motion for summary judgment phase, his arguments were that, one, we expressed a negative attitude. Two, the employer failed to adhere to established policies. And then the next one is he tries to outright say the reason we discharged him was false. Now, take him in.
Wasn't it false, counsel? The reason for the termination?
No, Your Honor. In fact, it's interesting that opposing counsel is the only one that doesn't believe that Mr. Burns couldn't do the job when he returned to work. Now, I think you're pointing in on the separation notice.
You don't say the reason for the termination is his inability to do the job. You said in the notice it was lack of work, which obviously was not true, because at the same time, you were seeking to hire other carpenters.
Not at exactly the same time.
Well, within a few weeks.
Within a month or
Okay.
so.
Let's call it a month.
Yes, sir. As Ms. Keeling's uncontradicted testimony says, Ford's hiring practices are fluid. Also, her uncontradicted testimony says that it was lack of work that he could do. It is undisputed based on the record, drawing all reasonable inferences in his favor when you look at the emails. The very evidence he's trying to rely on supports our position. The email says in the record, Mr. Burns wants a second opinion. He disagrees with Dr. Brophy. The emails show that he's...
That's not unusual that a claimant would disagree with Dr. Brophy, is it?
It is not unusual. However, there's the other evidence, the uncontradicted evidence of issues with light duty. Mr. Burns being unable to stand with flagging, Mr. Burns unable to weed eat, and these are items and tasks well below the extensive physical requirements for the job of carpenter, which is in the record in the hiring literature for Mr. Burns. The physical requirements for the job of carpenter require him to stoop, bend, stand for extensive periods of time, and lift items over 100 pounds. This gentleman was complaining about holding a weed eater, and he was also complaining about standing doing flag duty. Therefore, at this point in time, and that goes all the way back to April, and it continued until he was discharged in July, and the record shows that. And, Your Honor, in his reply brief for the first time, he cites to the TWB case. I did not have the opportunity on paper to address that issue, but in front of this court, TWB is the exception. It is not the rule. This own court in the Hill-Bourne case, 2013 Westlaw 1136540, said that the credibility concerns that warrant denying summary judgment must raise to a level higher than normal credibility questions that arise whenever a witness testifies. Any rule would essentially prevent the court from granting summary judgment in any case. My opponent would have this court say that every time a 30.026 designee gives testimony, you can't use it for summary judgment because they're biased because of their position. He has brought forth no evidence that Ms. Keeling's testimony is contradictory. The only thing, admittedly even close, is her further explaining the separation notice, which is a pre-printed state of Tennessee form filled out by a run-of-the-mill employee. Lack of work that he could do. Going all the way back.
No, it doesn't say lack of work that he could do.
I cannot deny that they did not fill out the further explanation.
Right.
But it's undisputed before this court right now, based on the evidence in the record, that Mr. Burns could not then do the work and he can't do it now. So what this court's faced with is we're dealing with a situation where we have a gentleman who says he's been wrongfully terminated from a job he admittedly can no longer do. And, Your Honor, that gets us all the way in the burden shifting to the legitimate reason. On page 3 of his brief, My opponent admits we put forward a legitimate reason. So now we're at the pretext part where he's trying to prove it's pretextual. Well, there are three ways he can do that. He can show that it has no basis in fact. Well, Your Honor pointed out the record's clear. We had proof that he couldn't do the job, and he admits he can't do the job, and the expert designation deadlines have passed. All the discovery deadlines have passed before this motion was heard and ruled on. All right, well, then you can go to, if they have a basis in fact, they can show they were not really the factors motivating the discharge. So my opponent's in the unenviable position of showing that despite admittedly he can't do the job anymore, that's not the real reason we let him go. I mean, it's a very unusual situation. And that's why in Leatherwood, the Leatherwood case, which has been the law of the land for decades, said, admittedly, it was mostly a judicial estoppel case. However, the court went further and said that a company, when they terminate an individual, does not have to create a new job for him. We do not have to have permanent light duty. When he was released to full duty, Ford was placed in the horns of the dilemma of making the decision of believing Dr. Brophy or believing him, and for safety purposes, we decided not to put him back out on the highway trying to lift 100-pound items and injuring himself, his coworkers, and the public at large.
Between April of 2019 and July, when he was terminated, was he still assigned light duty that
Yes. The entire time, Your Honor, and the entire time the undisputed record will show he complained about it. He complained about it, and then Brophy, in the July meeting, July 14th, he says, no impairment rating, return to full duty July 24th. Right away, he's asking for a second opinion right off the bat, and I know that's not uncommon, but when you put that in totality with all the other complaints of pain and the inconsistencies, we could not put him back out there. And the law clearly says we do not have to keep him on light duty. So, Your Honor, if you look at the pretext, and under McDonnell Douglas, I can get summary judgment on any trip across what I call the tennis net when the burden shifts. He has to show that with compelling evidence that lack of duty work that he could do is not the real reason we let him go. And the undisputed facts show that he cannot do this job. So, Your Honor, let's go over some of the items that he talked about and address them. We've already addressed the TWB. The negative attitude, which is more in the prima facie case than the pretext. The negative attitude in those emails, even when you view it in the light most favorable to him, all they show is we're adjusting a workers' comp claim. The court said that in his order. There is a distinction between investigating a workers' comp claim and actually terminating somebody for seeking workers' comp benefits. I mean, we need to look at the totality of this record. The gentleman gets injured in December. We send him, and we accept the claim right away. We send him to we send him to physical therapy. We send him to 2 different doctors, and we keep working this claim. And at the end of the day, when he asks for the second opinion in totality with those other complaints, we're not going to put him back on the highway to do bridge work. Now, some other items he pointed out. He says that there's no proof in the record of any safety concerns. Your Honor, those emails in and of themselves, the very evidence he points to are evidence of safety concerns. The language in there says we need to do what's best in for the employee. The emails actually also say, remind him of his managers of his restrictions, keep an eye on him. The keeping an eye on him isn't some cloak and dagger plan hatched at Ford Construction. The keeping an eye on him is so the gentleman doesn't hurt himself further, to keep the workers' comp claim down and to heal him. So, Your Honor, looking at those emails, they actually support us. And the only reasonable inferences to be drawn for them is that we were looking out for this gentleman's health. Now, he goes into the application after the fact. And after we had terminated him, he comes back in September, and in the morning he goes in to apply. And as this court's aware, you cannot base a wrongful termination case on speculation. He was not in the room with anybody. He does not know the validity of the statements. He didn't follow up on that in discovery. So that in and of itself is not proof of a prima facie case. Second fact, it's after the fact. And Tennessee law is clear. There's no such thing as a wrongful hiring for having previously filed a workers' comp claim. Secondly, apparently the concerns of warning the employees that he might come back again were fair because he recorded everybody. So this is just what happens when people become adverse to each other. You remind your employees, hey, we've got an adverse situation here. Just a reminder if he comes in to remember that. That's not a sign of a prima facie case prior to termination. So, Your Honors, looking at all the evidence and going through and seeing that if he has substantial circumstantial evidence or compelling evidence of pretext, Your Honor, the court was correct in granting summary judgment. The undisputed facts show that this gentleman can no longer do this job and that he couldn't do the job at the time they terminated him. The discrepancy in the separation notice that admittedly apparently was improperly filled out compared to the uncontradicted testimony of Ms. Keeling is not compelling evidence to show that our reason was a mere pretext. And for those reasons, Your Honor, based on the record before you, you should affirm the trial court's grant of summary judgment. Thank you.
Your Honor's TWB case is cited on page 13 of my initial brief. It's not undisputed that he could not do the work at the time that matters in this case, at the time that Ford made the decision to terminate him. The record at page 226 contains Mr. Burns' testimony. He would have reported to whatever job they told him to go to. As far as work comp was concerned, he was released full duty, no restrictions. He showed up, put me to work. Had they put him to work and he started complaining about all these things and they came in like the Davis case and sat down with him and said, we have concerns. You're saying you can't even weed eat. How are you going to be able to do this job where you have to lift? Then maybe they would have a good argument that they were concerned about his safety. Had they discharged him and put discharge due to inability to perform job, then they might have an argument. These are all arguments that have been created after the fact, after the lawsuit was filed.
Counsel, didn't they know from April up until July, the time of the termination, that your client was complaining about light duty, couldn't do that, also complained that the injections that he was given was not working? Why would they expect that he could then, on July 26th, return to his previous job as a carpenter? I mean, why would they expect that?
They would expect that for several reasons. One, Judge, taking the emails in the plaintiff's favor, when you interpret those emails and the inferences from them, the emails are chock full of statements where they say, we think this guy, they use the word malingering, we think he's faking. So, yes, they could completely, and then they have statements in there where they say the safety director saw him lifting heavy items over his restrictions. So it's not that they were saying, they had all of these things where, but it's the inference you draw from those. Yes, Ford draws the inference, we cared about this person, we had a safety concern. The inference that can be drawn in the plaintiff's favor, as it should, is we thought the guy was a faker. We couldn't stand his claim. And so as soon as he was released full duty, we said, no, we're not putting this guy back out there again. He's going to fight. And, we didn't get into the privilege log at all, but the privilege log from that weekend showed documents were withheld in anticipation of litigation. Well, what litigation were they withheld for? Because he was going to be moving forward with a lawsuit for workers' compensation benefits.
I know you don't want us to look at or consider Dr. Chung's report, but we know from his report that Ford was right, that Mr. Burns could no longer do his job as a carpenter for Ford Construction Company. Don't we know that?
No, Your Honor, and I'm running out of time, but I would say I think Your Honor, before taking the Court of Appeals, was a longtime Chancery Court judge, probably did many cases in Chancery Court and work comp cases, and knows there's a difference between what an authorized treating physician says and what an IME physician says and what ultimately the person can do.
So are you suggesting that Mr. Burns could actually go back and be a carpenter for Ford Construction?
I'm suggesting that he said he would have tried. And people do things all the time as long as they can to bring an income for their family until they can't do it anymore. 2 years after the fact, in a deposition, looking back and saying, yeah, I don't think I could do that anymore. He said that.
Okay.
All right, the case is submitted. Mr. Holliday, Mr. Cresswell, thank you for your arguments.
Thank you.
Ms. Dempsey, if she'll call